Welcome to corporate and commercial practice. This is going to be a video which might last for 1 hour, but still I might not be able to exhaust everything, but I will do my best. And please pay attention as I go through this analysis. And if you can listen up the end of this video, I will give you free tips on how to pass an oral exam. So we are saying that this model deals with establishment of various businesses and structures that enable clients effectively run their businesses. There is a very wide range of businesses that can be set up in Uganda. Legal practitioners are oftentimes called upon to advise on formalities for the formation and management of these businesses. It is therefore important that the lawyers are equipped with skills to enable facilitate the setup and running of these businesses. So basically here we shall look at a different kind of business entities that can be set up in Uganda, among which we shall look at sole proprietorship, partnerships, companies, limited liability partnership, general partnerships, private companies, public companies, and single member companies. So if you want to understand where each company applies or where do you advise clients to proceed with what, please watch up the end of this YouTube video. Then I'm going to clearly explain where you advise a client to apply what, and also in preparation for an oral exam, because you might be faced with such facts. So please join me, and then we can discuss this. So we are saying that the aims of this workshop are two. One, the aim of this module is to 1. Develop the ability to advise on business setup and management. 2. Develop ability to set up businesses. 3. Develop the ability to structure the management of businesses. 4. Recognize and resolve issues arising in setup and management of business entities. So basically here we are going to look at the ability to advise on business setup and management. So how do you set up a business? What are the formalities required? And then what are the management requirements also. So we look at ability to set up businesses, and also the ability to structure the management of the businesses. So learning outcomes, by the end of this module, we should be able to explain features of various business associations, sole proprietorship. Let me hope that we all understand what a sole proprietorship is. When you have a business which you own by yourself and you don't have any other owners. We also have partnerships, and we say that partnership, this is when 2 or more people come together and they make a business, and this one is always governed by the Partnership Act. So we have also general partnerships. General partnerships, these are partnerships where the liability of partners is unlimited, whereas limited liability partnership, here in these partnerships, some of the partners, they have their liability limited. So that's what the distinction between a general partnership and a limited liability partnership. So you have to understand that, because they can also ask you in oral questions to distinguish between a general partnership and a limited liability partnership. But what is important to note here is that whereas in the former there is general liability, that the liability is not limited, in the limited liability partnership we have one partner who enjoys or one or more partners who enjoys limited liability. So we also look at professional partnerships. These ones include like lawyers and accountants, and the Partnership Act provides that they cannot exceed beyond 50. Then we also have company, private and public. Then we shall look at NGOs, incorporation of trusts, single member company, private and public companies. So establish an appropriate business association for your clients. So basically here is according to the facts that the clients give you that you advise basing on. Then the other one is draft documents necessary for the establishment of business associations. So basically we shall look at different documents that can be required for you to establish different entities of company. Then 4, recognize and resolve issues relating to business establishment and management of business entities. So basically here we are looking at compliance with the laws and regulations, and also disclosure, making sure that you are disclosing all the requirements that might be asked by the regulators. So part A, we are saying that Jackson Matsumoto is in your chambers and relays the following information to you. He has been engaging in the business of selling sports, jerseys and casual wear for men. He carries out his business along Luum Street, Kampala on Mugaga Mall because of challenges of high rent in Kampala. He convinced his friend Jonah, fireman, whom he went to high school with, to come and carry out his business of selling perfumes in the same premises so as to reduce rent. This was way back in 2020 after COVID-19 lockdown. The two friends would contribute money for rent every month to reduce costs. This went on for 3 years and the two friends were really happy. So basically what you have to understand from this statement or from this paragraph is Jackson Matsumoto started as a sole trader or sole proprietor. Then he evolved into an informal partnership. So they went into a partnership which was not registered. So we call that an informal partnership. So in 2023 November, they decided to make the business bigger. They decided to combine their resources so that they could import merchandise directly from China and in Indonesia. They started running the business under the name and style of NRA Commandos because they sold a lot of military looking cargo pants similar to the ones used by the US military in Desert Storm in 1990. These paints are popular among the young generation. They did not formally register their businesses or carry out any formalities. They raised the sum up to USD 29,000 and started the business. Their business has since grown and their capital has risen to over USD 35,000. Jonah brothers-in-law Spriano Makiso, a South African national, has piqued interest in the business of Jackson and Jonah. So here the key question to ask yourself is, can a national join a business in Uganda as a partner? And of course the answer is yes. He is ready to invest some of USD 100,000 in the business and benefit from the growth of the business. However, he has no time to run the business with Jonah and Jackson. He works in Ethiopia and comes to Uganda once twice a year to check on his family. He wants to be protected from any business failure to the best possible extent. So basically here, this one, if he wants to be protected from any business failures the best possible extent, that means he can enter into as a limited liability partnership. Because remember, we have said that in a limited liability partnership, we have one partner whose liability to the losses of the business are limited. And so here we can look into whether the appropriate remedy would be a limited liability partnership. So he wants to be protected from any business failure to the best possible extent. Jackson's girlfriend, Murungi, graduated from Makerere University 4 years ago with a degree in marketing. However, she has failed to get a job. She is a very good marketer and can offer her services to the business in return for a stake in the business. So basically here we see this Murungi, who finished Makerere 4 years and also wants a stake in the business. So Jackson tells you that along with Jonah, Spriano and Shire would like to formalize the business, carry out their affairs. They do not want a lot of formalities and would like you to run a simple and efficient business which relies on and benefit from their personal expertise without creating unnecessary corporate structures. So basically here, this is where the examiner guides you. When he says that two or more people are coming together to form a business, that basically means that it's no longer a sole proprietorship. You have gone outside the jurisdiction or the limitations of sole proprietorship. So now we are looking at what? At partnership. Then when the examiner states about without unnecessary corporate structures, that means he's putting companies out. So the best possible business into here would be a partnership. And remember, also have to be keen, because partnership, we can have a general partners where the liability of the partners is not limited, and we can also have a limited liability partner where one of the partners' liability, the losses of the business are limited. So task 1 is formalizing instructions. I think we looked at formalizing instructions in civil litigation, and we said that this one is done by an engagement letter, so we don't have to go deeply into that. Then 2, extract any missing information to enable you to execute your instructions. So basically here, you will ask key things you might want. For example, what are the capital contributions of these partners? What role will be played by these partners? When will the partnership be terminated? How will they recruit new members in the partnership? So basically here, the information you are getting is what will help you to draft your partnership deed. So C, advise your clients on the nature of business relationship between them, tracing from the time Jackson started running that business. So Jackson started running as a sole proprietor, and then they evolved into an informal partnership. But now we want the appropriate business is partnership, which is going to be registered. So advise your clients on any potential breaches of the law committed thus far and challenges they encounter in registering the business. So first and foremost, the breaches: 1, there is non-compliance to the tax. The taxman, because they are not paying any taxes as so far. Secondly, they are operating under business name, but they have not registered it. That is fair to register the business name under the Business Names Registration Act, and also these people do not have a license under the Trading License Act. So those are some of the potential breaches they have done so far. So assuming Jackson and Jonah are agreeable to co-opting Cipriano and Shire, draft the document necessary to register the most appropriate businesses for them. So basically how we are going to look at a partnership deed. So basically a partnership deed, we look at capital contributions, we look at roles of the partners, we look at the duties of the partners, we look at termination of the partnership, we look at recruitment of partners, decision makings, and all those stuff. Then they will also sign. But remember, we have the case of Dr. Okello versus Komakech. It's High Court Civil Suit number 30 of 2006. That case basically talks about the registration of partnership deed, because what happened is Dr. Komakech, Dr. Okello had entered into an agreement with Komakech to buy a taxi, and then they are going to share the proceeds. So after, I think they had disagreements in how they were sharing proceeds, and Dr. Okello sued Komakech. So Komakech defense was that there was no any partnership agreement between the parties, that what the person had already done was advance him a loan, but was not a partnership. And his reasoning was that the partnership, if it was not even registered, if it was there in the first place. But then the court said that for there to be a valid partnership, it does not need to be registered. So that means that failure to register a partnership deed does not invalidate the partnership. So you have to be conscious of the decision in Dr. Okello and David versus Komakech Stephen. So they are saying that the document should offer as much protection to the parties as possible, considering their unique circumstances as highlighted in the facts. So when you coach those sections, you should take care into the interest of these different parties. But also before that, we shall have to register the name under the Business Name Registrations Act. So advise Jackson, Johnson, Cipriano, Shire on the necessary licenses and registrations to lawfully carry on businesses. So the registration, we shall have the Business Name Registration and the Business Name Registrations Act. You have to get a trading license and the Trading Licensing Act, and also tax registration to get a TIN, tax identification number, basically for purposes of paying taxes. 7. What are the likely challenges for you envisage considering the business entity your clients opted for and the unique circumstances as highlighted in the facts? So basically, here we are looking on business name registration. This NIRA commando might be rejected to be registered as a business name because it has some army connotations which the registrar might decline. Then also, they might also be fined under the Income Tax Act because they were receiving an income and they were not declaring their returns. So here also look at the possibility of fines. So task 2, assume that on 11th July 2024, Jonas, Priano and Shiri perished in a road accident. This was after the business has been formalized as envisaged under task 1 above. The business had no business continuity provisions in the document. At the time of the death, the business owed several suppliers and creditors, some of Uganda shillings 780,000. The business itself was worth Uganda shillings 450 billions. So basically here what we are looking at is the Partnership Act provides that unless the parties agree otherwise, then upon the death of one party, the partnership shall be terminated. So that's why we are saying that part of the rights and obligations arising between and amongst Jackson and families of his deceased business partners, rights and obligations. So basically what you have to understand here is, in a partnership, and I haven't looked at the revised act, but those ones who will be with us in our discussions at masterminds, we are going to look at that. We are saying that the estate of the deceased partner are entitled to the share of the partner who deceased, and so that means that these ones have to be paid, but also the rights and obligations of Jackson, of the remaining partner, you have to pay this debt we are seeing of 780,000, because remember, in a partnership you have unlimited liability. So you also have to pay this debt from suppliers and creditors, but also to give the estate of the deceased its share. Of course, there are provisions in the Partnership Act which provides for these ones, and I think we are going to look at them. So the purpose of this discussion is basically to highlight you on the principles of the law, and you can go and fill in the details. But also, this can be a very good discussion for purposes of an oral exam, because an oral exam, they will give you these facts, and you have to really be giving a honest, principle-backed opinion. So draft and register necessary documents to reflect the changes arising from the death of Jonah. So basically here, it shall be the notes of we first have the notes of death of a partner, then also notes of dissolution of the partnership. That's if there was no continuation, if there was no continuation clause. So you produce a notice of death of a partner and also a notice of dissolution of partnership. So assuming further that after fulfilling the obligations under task 2.1 and 2 above, Jackson has learned from experience, is wary of his business collapsing in the event of him dying in an untimely manner as his former business associates. He has continued in the business alone since the death of his business associates, but wants to formalize the business. He intends to continue owning it alone. He wants to ensure that even if he dies, his business continues as an entity of its own. Jackson is married to Shera Mumba, and they are blessed with one child. Jackson has a brother, one Peter Mukuzi. Peter, who occasionally helps him with purchases. He trusts his wife and Peter in the event that he meets his maker in untimely manner. So I hope that most of you have not had a single member company, but here the facts allude us to a single member company. So basically, a single member company entitles you to all the advantages of having a company, but here, like how the name states, you are the single member. You are the single member. So remember the decision of Solomon versus Solomon. If you have read it from the undergraduate, the facts were that, of course, this was a director who was having a business of making shoes. I think it was sole proprietorship, but then he went and acquired credit. So after acquiring credit, the business later was wound up. So when the business was wound up, the question was whether this director could still be responsible for could still be responsible for paying back the debt. So of course that's when we see I think Lord Denning bring in the principle of corporate personality, that a company and its directors are different people in the eyes of the law. So you cannot hold a director liable for the action of its company. So the fact that the company had been wound up, that means that the creditors couldn't recover from Solomon, despite the fact that he was a single director in the company. So that decision is really very important because it brings about all this doctrine of corporate responsibility, and also corporate being a legal entity. So in a single member company, you are enjoying all those benefits, but you are the only one person. However, they are saying that advise Jackson on the most appropriate business entity to set up. So I have gone for a single member company. Then what roles would Sheila and Peter play in the business? So during incorporation of a single member company, a single member shall nominate 2 individuals, one of whom shall become a nominee director in case of death of the single member, and the other shall become the alternative nominee director to work as the nominee director in case of non-availability of the nominee director as provided for under. So it used to be under section 186 subsection 1 of the Companies Act, but I haven't looked at the revised section. But here, so basically here we have Sheila Mumba and Peter Mkuzi. So one of them is going to be appointed as a nominee director, and the other is going to be appointed as an alternative nominee director. So the impact of that is, in case of the death of Jackson, then the wife can immediately take over, either change the company into a private company. But also, in case the wife is not around, then we can look at this alternative nominee director. So let me hope you have understood that. That's really still my opinion about this task. So extract any missing information necessary to execute your instructions. So basically here, you will have to ask this person, for example, things like business name, how do you like your single member company to be called, what's the capital structure, how many capital do you want to begin with, and what will be your office of the company, things like that. What's your national, do you have the national ID? So these things which are important in you to register the company. So when we look at part B, use the facts in part A, task 2, subsection 2 and 3 is the following modifications. Jackson has since decided to set up another entity with good and sound corporate structures. He wants the entity set up under part A, task 2, hold a significant stake in the new entity so as to be able to make any decisions. He also wants to co-opt his wife and son of minority age into the new entity as co-owners. So his wife is not bringing any money into the business, but will help in managing it. Jackson wants to protect the stakeholders of the new entity from loss of personal property in case the business gets into financial distress. So basically here we are looking at stakeholders. So that stakeholders can also mean as shareholders. Because Jackson is not very well educated like his wife, he wants the wife to help him in managing the business, but with him being the overall person in charge of managing the business. Jackson also wants to ensure that through the entity set up in part A, task 2, subsection 3, he maintains control of the business just in case his wife grows a big head and tries to disturb him. So they are saying that extract any missing information to execute your instructions. So basically here we would also ask about the capital requirements, the name of the company, and the directors, and also the share capital. So basically here we would look at decision making should be in relation to what, to the shares owned, because if the person wants to control the wife, then that means you can say that we shall make decisions according to the shares we have. So he can take like 90% of the shares and he gives the wife 10%. So as he can really control the management of the company. So advise Jackson on the most appropriate entity to set up, and that would be private limited company, because we are looking at here at stakeholders or shareholders. A partnership doesn't have shareholders, neither do a sole proprietorship, and a single member company doesn't also have shareholders. basically we are looking at nominee and representative directors, and also a public limited company has shareholders, but for it has some kind of this is not the intention of Jackson. So we are saying that draft the necessary documents for 2 above using information you have obtained to set up the entity that suits Jackson's interest. So first and foremost, for a company you have to first reserve a name, statement of nominal capital, notice of beneficial owners, memorandum and articles of association, statement about the director. So if you have registered a company, and now we always do it online, I hope you have looked at these documents which are necessary for you to register a company. So these are the documents we are looking at here, and are the same documents that we are going to have to draw. So ensure that your fees get paid. So you have to also ensure that you have charged appropriate fees. Also 5, assuming that entity above has been set up, draft the necessary documentation, call the necessary meetings, and set up management structures of the new entity. So basically here you have to understand the different types of meetings that are available for a company. The first one is the statutory meeting, and the statutory meeting always happens before the expiry of 6 months after the incorporation of the company. Then you have an ordinary general meeting, which always happens almost every year. Then an extraordinary general meeting, which happens when there is an emergency. So for you to call a meeting, first and foremost, you have to issue a notice, which is always 21 days. And then from the notice you come out with a resolution. So a resolution can either be an ordinary resolution, or according to the meeting you have sat, it can either be an ordinary resolution or an extraordinary general meeting resolution, or a statutory ordinary meeting resolution. So assuming that the business you have lawfully set up has been running for a period of 55 days, complete and file the necessary documentations. So we are looking at documentations which are required to be filed after the document has been incorporated. 1, we have the members register. Then return of allotment. Return of allotment basically looks at how many shares have been allotted to each shareholder. Then annual returns, you have to file annual returns. Notice of registration of place of business, also have to file these documents. So basically here we are looking at the documents which must be filed after the company has been incorporated. So let me hope you are enjoying the discussion so far. If you love business, I think it's going to be a very good week, but it's going to have a lot of writing, but I'm sure we are going to do that. We are now used. So task 4, through the entity set up in part B. Task 3, Jackson wants to help poor vulnerable children from his village in Chasampata, Busuju Actual District. He wants to put aside a fund from the profits that his business in part B makes, so that the entity can sponsor education of the best students at primary level education amongst all the UPA schools in the sub-country. The directors in the entity setting up the entity to cater for the children are Jackson and his wife. Advise Jackson on the most appropriate entity to set up to help the vulnerable children in his village. Give reasons for your answer. Of course, it's an NGO, and the reason is because it's a non-profit oriented endeavor. Then 2, extract the information required to execute these instructions. So when you're going to register an NGO, the information you would want is the name of the NGO, where is it going to be located, and most importantly, the source of funds, and also the directors of the NGO. So this is really very important information that you cannot even proceed to register the NGO if you don't have. So what are the authorization and processes flows required to set up the entity in tasks 4 part 1 above? So you have to apply for registration in the National Bureau of NGOs. You have to have a certificate of incorporation. You have to have the organization constitution. You have to have recommendation from the district's NGO monitoring committee. You also have recommendation from the relevant ministry. So here it would be the Ministry of Education, and also other government departments and agencies. So these ones are under the NGO Act. Let me hope you can go and read the NGO Act. All these ones are there instituted. The NGO Act, or I think the regulations. But what I can tell you is these ones are the creatures of what? Of the statute. So draft the relevant documents or size in the entry to set up in Part B, Task 3, to set up whichever charitable organization you will have to opt for. So basically here we are looking at, of course, you have the application for registration, certificate of registration, and also a permit. So you must have a certificate of registration and a permit. So personal readings exercise. Draft documents for resignation from a partnership. This is a notice of resignation, and it's provided for by the Partnership Act. Draft pleadings for dissolution of partnership by way of court order. State the grounds for dissolution and sanctity. So basically here you have to clearly draft these pleadings stating the grounds and the prayers. What are you praying from court, and what are the grounds? For example, maybe one party has been insane, and also are praying that the court terminates the partnership. So some of these grounds are set for by what? By the Partnership Act, and here they have called them pleadings. So reading their entirety, Table A, Parts 1 and 2, and determine which part applies to private companies and public companies. B, C, D, E, F of the Companies Act, you ought to know when to apply each of these tables. So these tables are always found in the Companies Act. I think in the schedules they are in, I have to look at them. These tables provide models of articles of associations that may be adopted by private or public companies. Table B provides the format for a company limited by guarantee. Table C, D, E, and F apply to different forms of companies such as unlimited companies and companies limited by guarantee with or without a share capital. So let me hope that you understand the difference between a company limited by guarantee and a company limited by share capital. So a company limited by guarantee is where the liability of members are limited to the only amount they have guaranteed, whereas the one for share capital is only limited to their share capital. So for example, I could say that I have only my liability to loss is only guaranteed up to 50 million. So that becomes the company limited by guarantee. So fill in necessary statutory forms under Part C above. So here these are the documents we have looked at: letter of allotment, notice of change of directors. All of them are there in stipulated. So look up a minute book of any company online and note how resolutions are registered in the minute book. Attempt to fill in details of resolution in the minute book. So a minute book is a formal record kept by a company that documents important decisions, resolutions, and meetings such as board meetings and shareholder meetings. So a minute book is really like it keeps record of the company in relation to board resolutions, in relation to documents, and the Companies Act typically requires companies to maintain a minute book as part of good corporate governance principles. So corporate governance basically looks into the basic principles of how you can manage a company, including auditing, accountability, proper management. So for those ones who will have to do corporate governance as an elective in term 2, you will go deep into these kind of things. But I wanted you to understand what a minute book is for purposes of this discussion, that also it can be your oral question. So assume you are a company secretary of a private company, what documents would you need to maintain to ensure good sound corporate governance? For example, I've already talked about a minute book, then also tax compliance certificates, annual returns, and filing the register of members. So what evidence would you keep to ensure that you have evidence that any meeting in issue was called according to the law, notice where necessary was served, the meeting had the required quorum, and the minimum threshold of voting was required. So in summary, as a company secretary, maintaining comprehensive records such as notices of meetings, attendance registers, minutes, voting records, and proof of service of notices ensures that all corporate governance procedures are transparent. So these documents are evidence demonstrate that meetings were called and conducted according to the law, ensuring that the required quorum and voting threshold. So basically here I have to keep the voting registers, the attending registers, the notices, all that stuff. So Company XY Limited was incorporated with share capital of Uganda shillings 100 million divided into 100 ordinary shares of 1 million each, and the following persons subscribed for shares as follows: Bide Wanga 60 shares, Jane feel a return of allotment for the shares above. So in Uganda, a return of allotment, also called Form 18, is used to notify the register of companies about the shares allotted by company below. So basically here, for you people have filed or incorporated companies, you find that here they will say that you put the number of shareholders and you put shares on each. For example, if there are 100 shares, you say custom may be 80, this one 20, just like that. That's what we call an allotment. So assuming that later another 15 shares are allotted to be one fee in return allotment in respect of the shares so allotted. So basically the same thing. You have to also make sure that all the shares have been divided, and you know how much does each share contain. You get, that's the point. It's simple few mathematics here, but it's not about understanding the mathematics, but understanding the general law applying to allotment of shares. So draft a trust deed. So a trust is a legal document that outlines the terms and conditions of a trust, including rights and responsibilities of the trustees and the beneficiaries. So then we have a special note there. So let us proceed to workshop 2. But before I proceed to workshop 2, you know, I'm not covering in the details, but on Saturday we always have discussions from 4 up to 6. It's always online, and we get delve into deeper into these sections of the law. We can also see these documents. Then on Sunday from 4 up to 6, we go into workshop 2, whereby we also dive deeper into the law, the principles. We can also see these documents. So in case you want to be part of that mastermind group, whereby we can go into detail, you can really inbox me and I tell you the requirements. Then you will be part of that group, because however much I would like to share everything here, but I see almost we are almost completing an hour, and we have not to move to workshop 2. So in case you want summarized notes of all workshops and in time, to help you to begin copying notes in time, then you can reach up to me, and then you'll be part of that mastermind group. So workshop 2. So the aims of this workshop are to develop your ability to hold various company meetings. So we talked about various company meetings. One is a statutory meeting, which is always held 6 months from the date of incorporation. Of course, I haven't looked at the revised act. I will look at it and then see what does it provide, but I wanted to get that. Then the second one is ordinary meeting. These ones are always held every year once. Then the extraordinary general meeting, which is always when there is an emergency. Develop the identity and deal with shareholders' rights. So basically here we are going to look at the case of Lukakile versus Incafex. It's a very popular case. It defines who is a member, it defines who is a shareholder, and it defines who is a subscriber. So it's really very important to read this case, because this one can be an oral question. Distinguish between a subscriber and a member of the company. But briefly, in that case, what happened is Lukakile sued John Garuga. So John Garuga is the director of Incafex. So Lukakile sued him, alleging that there were mismanagement in the way the company was being run. So of course he proceeded by petition to the High Court, and then defense of Lukakile, the director by then, or here we are calling Incafex, because under the corporate principle of Solomon versus Solomon, a company can only sue and be sued in its name. You can't sue the director. But for you who know, John Bosco Garuga is a very wealthy businessman from Kanungu, very popular of growing coffee, and even has a lot of beaches here in Kampala. You have heard about the Garuga beaches. That's the proprietor. He's a very wealthy businessman. So, but important to our case is that his defense was that the petitioner was not right even was not had no locus sue because he was not a shareholder of the company, that the 450 shares he owned, he was only owning them in trust of a foreign company. So that by that effect, so he had no mandate or locus to bring a suit against the company. So of course that case goes into define who is a subscriber, who is a member, who is a shareholder. And it's really very important that you understand those definitions, which I cannot really go into detail because that would be against the scope of this discussion. But what I want you to understand is, of course, he was said to be a shareholder, and then here the method of procedure or the documents was a petition supported by an affidavit. So European capacity to convert the company from private company to public company, and ISCO issues arising here as from shareholder disputes. So illustrate the process of holding company meetings. So we talked about social meetings. We have already talked about all these ones. Illustrates regulatory compliance processes. So basically, here a board resolution and notice of, you have to issue a notice of the meeting, which must be in 21 days, and then a resolution from the meeting. So we have talked about the rule in First versus Haboto. I hope that we have looked at this case, First versus Haboto. When I first heard of this case, I was very fascinated of the name Haboto, and the principle stuck because they said that the rule is that you as a single shareholder, you are not supposed to bring a suit against the company on behalf of the other shareholders, that they must have consented and you sue as a whole but not as a single shareholders. Of course, in that case, there was a mismanagement of company land whereby one of the shareholders had sold company land to one of his friends at a reduced price. So when one of the shareholders sued, the court stated that a single shareholder cannot bring a suit against the company on behalf of the company, the entire company. Of course, the rationale for that is to avoid the multiplicity of cases, but then the exceptions for this rule, and I'm sure that we have all looked at them at undergraduate, and one of those sections is when the shareholders' rights are being violated, or when the articles of association are being violated. So what we have from this section is the violation of a shareholder right, because one, we are not seeing that, as we are going to see, then for this demonstrate the process of converting a private company into a private company into a public company. Of course, here there must be a board resolution, then also an amendment of articles of association. We must also have shareholder approval, then application to the register of companies, and also change of the name. So recognize and deal with ISCO issues relating to the business establishment and management. Here we are looking at transparency and honesty and compliance with the law. So part A, assume that the entity set up in workshop 1 part B task 3 has been operational for a period of 1 year. You are the company secretary. You have been tasked with the duty of calling for an annual general meeting. The constitution of the company that you adopted in workshop 1 part B task C shall be your guide. Draft the necessary notices to convene the meeting. So basically here we have the notes of the meeting, which calls the meeting, and must be within 21 days, like they will have looked at, and it's for an annual general meeting. So you only draft the notes for an annual general meeting. Draft the agenda of the meeting. So let me hope that we all know what an agenda means. At least we have been at parties, and with they always read the agenda: opening prayer, the bride coming in, dance by Mugore. So here we are not looking at that, but we are looking at the chronological events on the meeting. So we always have a prayer, maybe by the chairman, then the reports from the auditor, just like that. The agenda of events to be discussed. Assuming that due to emergency and poor planning on your part, the meeting is called with notice of shorter than statutory minimum, what steps will you take to rectify it? So basically here you have to obtain consent from the members for a shorter notice, then issue a supplementary notice After obtaining consent indicating meeting will proceed as planned. Let me hope that that one is very clear. You have to obtain consent from the members. Then after them giving you consent, you issue a supplementary notice saying that having gotten consent, the meeting will still be held as you had earlier planned. What documentation will you provide for the members prior to the annual general meeting? Of course, here you have the notice, the annual financial report, the auditor's report, the annual financial statements, and the agenda, among other things. So part B, assume further that after the annual general meeting in part A above, Jackson and his wife developed a serious misunderstanding. The accounts presented at the AGM were also far from satisfactory and showed a dire state of affairs. This followed disputes between Jackson and his wife stemmed from Jackson over fraternizing with one of the sales girls in the business. Jackson has also taken advantage of his wife, forced absence, and his being a sole signatory to company accounts to use company funds in any manner he deems fit. He goes for expensive trips abroad with his new love using company resources. Jackson's wife has found out that the company is now indebted to Uganda Revenue Authority over taxes up to 67 million. Suppliers are also demanding sum of 7 billion for supplies made but not paid for. This had never happened while she was in charge. Jackson denied his wife access to company premises and will not let her look at the books of account. The company books of accounts of the company are also poorly kept. In fact, Jackson's wife has never been received a share certificate. She knows she is a shareholder but has never got any documentation save for signing the memorandum and articles of association. Advise Jackson with the wife on her rights and circumstances. Of course, you have rights to access company premises. You have rights to receive a share certificate, proper account and out of the books of the company. So those are the rights. Then remedies. Previously it was section 24 of the Companies Act. I haven't looked at the revised act, which provides for under subsection 1 that a member of the company who contends that affairs of the company are being conducted in a manner oppressive to some part of the members, including himself or herself, or she may make a complaint in the registrar by petition. So here the case we have is Rukakire versus Incafex, and I'm very sure that I really explained that. Then remedies in the circumstances. Then you can ask court order a proper account in the management of the company affairs. Also be allowed to access company premises. Be granted a share certificate. Draft and explain the necessary documents to seek the remedy you have proposed above. So we say that this one is going to be a petition accompanied by an affidavit in support. Part C. Assume that further in the conflict between Jackson and his wife above, Jackson was ordered by court to compensate his wife for her shares, which he has since done. The wife has since left the company. Jackson has since brought an extra shareholders in the company to stabilize it and ensure that he gets sound corporate management. His entity's shareholding in the company has also been directed to just 20%. The new shareholders have decided that the company should restructure so as to attract enough financing. They want the company to be open to any member of the public with capital to invest in it. So basically here we are looking at how do you turn a private to a public company. So remember that the private company, the members are always restricted up to 100 members, whereas the public company, the number of shareholders are always unlimited. So when the person says that, or when the examiner talks about being open to the public, that means he wants to look at how can you change a private into a public company. So advise the company on steps to be taken transforming it as per the wishes. First and foremost, you have to call a meeting, you have a resolution, you amend the articles of association, shareholder approval, then application to the registrar, and change of names, among other things. But those are the basics. Then draft the necessary documentation authorizing the transformation. Task 3, draft documents for raising capital from the public. So you have heard about IPOs, initial public offerings, where the company begins to solicit funds from the public for the first time. Most of you have bought shares from MTN, others from Airtel. So that process is called IPO. initial public offering, and for that to happen, it must be a public company. A private company cannot do that. For example, in the oral question, you can be asked that this person has a private company, but he wants to get money from the public. So how do you advise that? So you have to have in mind that the company must first be changed from private up to public. So draft and necessary documents, we have looked at notes of meeting, board resolution, then amendments to the memorandum and articles of association. So basically that is it for that. Then we go to workshop 3. Basically workshop 3, you are required to set up a class firm to take you through LDC. You must indicate what should be in a professional law firm. So basically what should be in a professional law firm? Of course, a professional law firm must have a reception, it must have a waiting area, it must have a boardroom, it must have the statutes, those law reforms. So what is the mission, vision and values of the firm you have set up? So the mission would be to increase the general performance at the law development center, and the vision could be enabling firm S3 to finish or pass the bar course within a specific time. So suppose some members have contributed to the partnership property, the LDC decided to discontinue them from the bar course and they have to leave. What is the fate and how do you handle them? God forbid, no one is going to be discontinued. We are going to all finish the bar course and pass. But here, that means you have to put a clause upon termination, or in case one member suggests to leave the partnership. For example, you can issue a refund, something like that. Suppose LDC admits new students who are meant to join your firm, how would you admit them? So basically here, the examiner wants you to talk about how one of the partners is going to leave the firm, how are you going to recruit new partners. Those are basic things he wants you to talk about. So discuss the process of establishment of the said firm, admission of new members, and retirement of the partners. So of course, the process of establishing a law firm, you know it. You must be an advocate of the High Court with 3 practicing certificates. You apply to the Law Council upon payment of a fee. You must have a fixed premise which the Law Council comes and then supervises. Then after that, they will want you permission to operate the law firm. So it's the purpose of the Law Council. Draft all the necessary documents. So basically, I want to draft a partnership deed, and basically for your law firm, and ensuring that you put clauses of termination of one of the partners, and also recruitment. So calculate all the fees payable. So you have to reserve a name. You have to register a name under the Business Name Registrations Act, maybe Firm S3 and Company Advocates. Then payment to Law Council, I think it's always 500,000, but there is a resolution to that. Then there's payment to Law Council, then registration of a partnership deed. So you have to register a partnership deed with, I think, URSB. So that's it for this workshop. It's going to be a very long week with a lot of documents and a lot of confusion. But if you want to go an extra mile with me, where we give you summarized notes, in-depth discussion, and also a WhatsApp group of focused members, we have a mastermind group where members pay only 100,000 per month, and basically is to support our research, buy statutes, and also get cases. So I work with a team of students who pass the bar course very highly. So please come and be part of our group. So if you have liked this channel, please like, subscribe, comment and share, and always don't forget to come back on every Friday to watch into my opinion or an in-depth analysis of the workshop that we are going to be doing the next week. So I promised you tips on how to pass an oral exam. Of course, preparation. Of course, there is one author who said that if I had 6 hours to cut, a tree, I would spend the first 4 hours sharpening my axe. And that's the same advice I want to give you, that you sharpen your axe. And like iron sharpen iron, and that's why I invite you to our mastermind groups, so as you can also be sharpened by iron. So thank you for watching. I really appreciate that. I don't take it for granted, and I have really done my best to provide value, and I really wish you success in your exams. And I'm very certain that if you can always come here and watch my analyses, go into discussion groups, attend workshops, then you are going to automatically pass the bar course. Please, God loves you, and He told me to tell you this, and He has a plan for you, and that plan is that you are going to pass the bar course.